Oyez, oyez, all rise for the Supreme Court of Tulane. You may all be seated.
Good morning, ladies and gentlemen. We are here. We have one case on our docket today, Bobby Bronner and Chester Comerford Petitioners versus State of Olympus and the United States Respondents. Are both parties here before the court?
Yes, Your Honor.
Are both parties prepared to go forward?
Yes, Your Honor.
Let me introduce myself. My name is Judge Frederica Wicker. I am the Chief Judge today, and I have with me two Associate Justices who I will ask to introduce themselves.
I'm Justice Tom Blakian.
I'm Tony DeLeo.
So that all of you know, before we begin, we have all read your briefs. We have read the cases which are, we believe, to be seminal. We have read the record. We have read the transcripts. So please understand that we're all thoroughly familiar with your case, and we will be strictly abiding by the time guidelines. Would the parties each please make their appearance for the record?
My name is Willem Daniel.
My name is Rachel Shonebarger.
We're appearing for the Petitioners.
My name is Brett Harris. My name is Alex Harris, and we appear for the Respondents.
All right. Is the petitioner ready to begin?
Yes, Your Honor.
All right.
Madam Chief Justice, before I proceed, may I reserve 3 minutes of time for rebuttal?
Yes.
Thank you, Your Honor. Madam Chief Justice, and may it please the Court. My name is Willem Daniel, and I, along with my co-counsel, Ms. Rachel Shonebarger, are appearing before the Court on behalf of the petitioner, Mr. Bronner and Mr. Comerford. I will demonstrate how the Affordable Health Care Act is not justified under the Interstate Commerce Clause, and Ms. Shonebarger will demonstrate how Proposition 225 violates the 14th Amendment. Before I proceed, would Your Honors care for a brief recitation of the facts?
We are thoroughly familiar with the facts.
Of course, Your Honor. Your Honors, this case is ultimately about the federal government forcing individuals to purchase a commodity they do not want. And that is unconstitutional for 2 reasons. First, a decision is not an activity, nor is it economic in nature. And second, even if this court is prepared to hold that a decision can be an economic activity, that decision does not have a substantial effect on interstate commerce. Your Honors, in Perez versus United States and United States versus Lopez, this court held Congress may regulate the instrumentalities of commerce, the channels of commerce, and all those activities that substantially affect interstate commerce.
You will agree, I take it, that the activities involved in health insurance as a general concept have an overwhelming effect on interstate commerce, do you not?
Yes, Your Honor, we do agree to that. We also agree that the government may regulate those problems and that market. However, what the government may not do is compel individuals to enter a market they have no desire to be in.
Well, let me ask you about this. So in the United States, we all know that we have millions and millions of people who are not insured. And so those people, when they get sick, engage in an activity. That activity is they go to an emergency room and they receive health care treatment for which they do not pay and which overwhelmingly burdens the other taxpayers and the United States budget through Medicare, Medicaid, and so forth. And so I wonder at your basic premise, which is that this is a regulation of, quote, inactivity rather than activity. Would you expound on that?
Yes, Your Honor. Congress may regulate that activity. Congress may regulate the manner in which individuals consume healthcare commodities. Congress may require individuals to pay for those commodities by reforming bankruptcy laws, or even by agreeing to pay for that healthcare commodities and then funding that through some sort of taxation program. The fact of the matter is, Congress requires an activity to trigger its regulatory power. And in this instance, no activity has taken place. As Your Honor mentioned, when individuals do enter a hospital and do consume commodities in some way, that is an activity that satisfies the court's definition of what triggers Congress's regulatory power.
Is admission to a healthcare facility always a voluntary decision?
No, Your Honor, it's not necessarily always a voluntary decision.
So it's quite possible that somebody who might make the decision not to obtain insurance would nevertheless have the right to obtain healthcare services.
Certainly, Your Honor, it is possible, and Congress may regulate how and whether they are entitled to receive healthcare commodities under that scenario.
And isn't that what this legislation attempts to do by spreading out the cost of healthcare so that individuals who do have insurance are not disproportionately burdened by the fact that people who do not have insurance participate in the system?
No, Your Honor, Congress is not regulating that activity.
But they're regulating the price, aren't they? They're regulating the price of healthcare services by having this kind of comprehensive legislation that requires participation in the system so that the benefits are shared equally among the participants.
Respectfully, Your Honor, they're not regulating the price. There's nothing within the Affordable Health Care Act or the individual mandate, which is particularly problematic, that speaks to price of health insurance or healthcare commodities.
Well, isn't that what the exchanges are all about? That to build a core mass so that you have the underinsured young people who are overwhelmingly healthy paying to help care for the old people who are overwhelmingly not healthy.
The insurance exchanges, Your Honor, are not particularly problematic. What is problematic is the individual mandate, which forces individuals to purchase a commodity. This court has never upheld any such regulation before.
And we have never struck it down either, have we?
Not specifically, Your Honor, but in National Labor Relations Board versus Jones and Law and Steel, the court upheld the National Labor Relations Act. In doing so, though, it specifically noted that nothing within that act compelled individuals to engage in any activity that they would not have otherwise engaged in. To do so, the court held, would be constitutionally problematic, just as it is in this instance. Since there is nothing to trigger Congress's regulatory authority, there is no economic activity, Congress does not have the authority to force individuals to enter a market. And whenever this court has found an instance of Congress regulating a non-economic activity, this court has struck down that regulation as unconstitutional.
Well, you're not arguing that this is a non-economic activity, that the whole notion of healthcare is non-economic.
Not the notion of healthcare, Your Honor. The notion of a decision is not economic.
But you would concede, for example, that the government could impose a tax on individuals and then use the proceeds of that tax to fund hospitals and insurers and so forth. So isn't this just a lesser included power of Congress?
Your Honor, they could do that, but not under the Interstate Commerce Clause. The Interstate Commerce Clause gives them the power to regulate commerce, and to do so requires an activity.
What's the basis for, well, you're saying that we couldn't, for example, if we could use the taxing power, how is this not just the equivalent of a tax?
Well, Your Honor, if they had taxed it, individuals could be forced to pay that tax. That would be acceptable. So, for instance...
Well, isn't that, for want of a better term, exactly what's happening? They're saying either you buy insurance or we are fining you. Isn't that just another term for a tax?
Well, Your Honor, in this instance, it deprives individuals of the choice of whether to purchase a commodity. We agree that individuals do not have the ability to choose not to pay their taxes. However, allowing Congress to regulate an inactivity would be too expansive, not just in this case, but in other cases. For instance, Congress could then require individuals to purchase cars in order to save the automobile industry, or to engage in other types of activities simply because Congress believes that is beneficial. And as the court noted in Lopez, doing so would effectively transform Congress's regulatory authority into a general police power. And that, the court said in Lopez, would effectively obliterate the distinction between the state and federal government.
But isn't this a unique type of service? I mean, you keep referring to it as a commodity, but it's a kind of unique service that societies have historically been compelled, or at least society, not particular governments, have been compelled to provide their citizens in one way or another. So can't we distinguish this legislation from the automobile purchase and so forth by saying that it's a service that by law one must provide even if the particular individual is unable to consent to enter into a contract?
That is a difference, yes, Your Honor. But the difference is in the healthcare commodity market and not, Your Honor, I see my time is up. May I finish answering the question?
Yes,
Madam Chief
you
Justice?
may.
The difference is in the healthcare commodities market and not necessarily in the health insurance market. Individuals should have the right to choose how to pay for their own healthcare consumption. And that choice is being deprived to them by the Affordable Health Care Act and the individual mandate. Thank you, Your Honor.
Would you reintroduce yourself?
Certainly, Your Honor. My name is Rachel Shonebarger. Honorable Chief Justice, and may it please the Court. My name is Rachel Shonebarger, and I rise to continue the arguments begun by my co-counsel, Mr. Daniel. I now turn the Court's attention to the issue of the 14th Amendment and how the state of Olympus has violated Mr. Bronner and Mr. Comerford's 14th Amendment rights through Proposition 225. This case is truly about two individuals, Mr. Bronner and Mr. Comerford. The two are in love and wish to have their marriage recognized. However, the state of Olympus refuses to do so, which is unconstitutional for two reasons. First, the right to choose whom to marry is fundamental, and therefore, the Court should apply strict scrutiny to Proposition 225.
Ms. Schoenberger, isn't the area of marriage one that has been uniquely within the ambit of the states? Hasn't it always, aren't you asking us to do sort of exactly what your co-counsel is asking us not to do, which is to mind somebody else's business?
No, Your Honor, that is not what Mr. Bronner and Mr. Comerford are asking the Court to do here in the case at bar. Now, we recognize that marriage is a state institution. The state has the right to decide who does and does not qualify for a marriage license. But whenever such a regulation has violated the 14th Amendment, the Court has stepped in to protect individuals. The power of the states is not unlimited. And since there is a fundamental right in the case at bar, the Court should apply strict scrutiny.
And you'll agree that no case has ever found that marriage is a fundamental right?
Your Honor, no, the Court has in fact found that marriage is a fundamental right. The Court, for example, in Cleveland Board of Education versus LaFleur, as cited within Zablocki versus Redhill, stated that people have always had the right, had this personal choice in matters regarding marriage.
But you're discussing the definition of marriage, right? I mean, to the extent that one has historically recognized the right of marriage between a man and a woman, that is constitutionally protected. Here you're talking about extending the definition of marriage. So should we consider that as a fundamental right going into this, or is that the output of the decision that we would be making?
Your Honor, Mr. Bronner and Mr. Comerford already have this fundamental right to choose a spouse. Now, while all cases in the table of authorities do deal with traditional marriage between a man and a woman, the Court has always looked to people's choice in the matter. Because, as the Supreme Court of Massachusetts noted in Goodrich versus Department of Public Health, the right to marriage means little if it does not include the right to marry the person of one's choosing.
Well, there you go. You're imposing a limiting principle. You're saying marriage is between two people. What if I say marriage should be among three people? Even though it hasn't been historically defined that way, I think it should be opened up in that manner. Your argument seems to be one about redefining the term marriage as opposed to advancing this strict scrutiny argument with respect to traditional marriages.
Your Honor, all three individuals in your hypothetical would have the fundamental right to marriage. However, a state could restrict this fundamental right because it passes strict scrutiny. And that is what is lacking in the case at bar. All have the fundamental right to marriage, but that right is allowed to be denied so long as the state has a compelling interest, and that interest is narrowly tailored to achieve the state's goal. However, the state in the case at bar has no interest that is compelling. Within the record, the state lists such interests as cost, public morality, and upholding the traditional views of marriage.
Does the state have the right to remain constant to the social mores which is prevalent within that state?
Respectfully, in the case of bar, no, Your Honor. The state of Olympus has used the views of the majority to discriminate against my clients, Mr. Bronner and Mr. Comerford. And as the court noted in Romer versus Evans, the bare desire to harm a politically unpopular group cannot constitute an interest.
Are you saying this is invidious discrimination, that marriage statutes were adopted for the express purpose of excluding gay men and lesbians from the institution?
No, Your Honor, only that in the case at bar, the state of Olympus's true goal is to discriminate against my clients. Originally, the institution of marriage was not attempting to discriminate against anyone because the society had only known marriage to be between a man and a woman. But that is not true in the case at bar.
Well, we have, won't you agree that this court has traditionally, as social mores evolved, given wide berth to the various regions, states, to allow their social mores to evolve to a point at which the people themselves as a group grapple with their concerns, and only after the question at issue has had lots of time to evolve have we interjected ourselves. Why would you have us do that at this juncture when the matter has been addressed so far by not many states and by many public referendums, all of which voted against the extension of the definition of marriage?
Well, Your Honor, Mr. Bronner and Mr. Comerford would like us to use the logic employed in Loving versus Virginia. And in that case, members of the state of Virginia thought it was immoral to allow someone to marry someone of another race. But the court struck down that law as unconstitutional, even though those within the state thought it was wrong, and held that people have the fundamental right to choose whom to marry.
Isn't the Loving case distinguishable, though, because in the Loving case, the state of Virginia made it a crime. In this situation, there is no crime. There is simply the statement by the state that it is not going to extend the definition of marriage.
Your Honor, the fact that Proposition 225 is not criminal does not make a difference in the case at bar. The commonality between the two cases is that a group of people is being denied a certain right, and that is unconstitutional without a legitimate or compelling state.
But if we subscribe to your argument, where do we close the door? Once the door is open, can you marry your sister? Can you marry your cousin? We've had the question, three people get married? Where do we draw the line?
Your Honor, the line has already been drawn at the test of strict scrutiny. A state can make any regulation upon marriage. It cannot allow someone to marry someone in their family or to marry a child because the state has a compelling interest to do so. For example, they're protecting children and not allowing an adult to marry a child. But the state, in the case at bar, has no interest for Proposition 225. Even if the court does not apply strict scrutiny and applies rational basis review, the state does still not pass.
What about costs? I mean, to the extent that this would greatly increase Olympus's, the cost of providing benefits and health care and so forth, that's what this case seems to be about. Isn't that something that the state can take into account in deciding which relationships it wants to subsidize?
Yes, Your Honor, in some instances. For example, in Plyler versus Doe and in Shapiro versus Thompson, the court stated that fiscal interests can be legitimate. But in both instances, the court struck down the statutes because a fiscal interest created an arbitrary distinction among citizens. And that is exactly what Proposition
Well, one
220...
could argue that, we're sorry to cut you off, but relationships that have the ability, have the potential for procreation, at least at the outset, might be entitled to some sort of government subsidy versus those where there is no such potential, and the participants could adopt, but that would be a voluntary choice as opposed to involuntary. Well, you may answer the question if you don't mind.
Thank you, Your Honor. Well, if we employed that logic, that would not allow the old to get married, or those who are infertile. An interest of procreation is not legitimate because homosexuals can also be great parents. Thank you.
And would you reintroduce yourself to the court?
Madam Chief Justice, Your Honors, and may it please the Court, my name is Brett Harris, and I represent the United States under the Commerce Clause. Today we ask this Court to rule that the individual mandate of the Affordable Health Care Act is a necessary and proper application of a larger regulatory scheme that is protected under the Commerce Clause. Now, time permitting, I'll be presenting the following three arguments. First, the Commerce Clause grants Congress clear subject matter jurisdiction over the health insurance industry. Second, the Affordable Health Care Act is a comprehensive regulation of the health insurance industry. And finally, the individual mandate then follows as a necessary and proper procedural component under this larger regulatory scheme. Now, this Court established in United States v. Lopez that Congress can regulate the channels, instrumentalities, and activities that substantially affect interstate commerce. And we can see that the health insurance industry meets all three prongs of this Lopez test.
But that's not what your opponent is saying. Your opponent is saying, and makes a strong point of the fact that this is not the regulation of activity. This is the regulation of inactivity, and we are now telling people what they have to do far beyond that which we have done in any other situation.
Madam Chief Justice, in fact, the Affordable Health Care Act and the individual mandate does not seek to go beyond where this Court has already gone before. I would disagree with opposing counsel and believe that the first step in answering your question is to define what constitutes activity in a market. What is the minimum threshold for activity in a market? We can certainly see that it varies from market to market. In the motel industry, as in Heart of Atlanta Motel Incorporated versus the United States, the minimum threshold was owning a motel. In Wicker versus Filburn, the minimum threshold was growing wheat, whether or not that wheat was sold on the open market, whether it was for home consumption.
And it's a voluntary decision to own a hotel that would grow wheat.
Yes, Your Honor. We can also look to Gonzalez versus Wright, which, again, involved the decision to grow marijuana. Now, obviously, the decision to grow marijuana, though it does justify activity in the marijuana market, would not justify you to be regulated under the motel market. So let's ask, what is the minimum threshold for participation in a health insurance market? Now, Mr. Justice, as you pointed out, the health insurance market is a unique market in that it is, in fact, properly understood as a risk market. Just like in Wicker and just like in Gonzalez, when someone decides to cultivate wheat or cultivate marijuana, or in this case, cultivate risk, they do cross the minimum threshold for activity.
Cultivating risk is a clever way of articulating this idea, but the only reason it's a problem is because we decide to subsidize hospitals, we decide to subsidize healthcare. Surely the federal government could just not provide that function to individuals who don't want to participate in the healthcare system, and then they can make the decision whether or not they want to participate.
Certainly, Your Honor, Congress could make that decision. In the present case, though, we are limited to asking the question, can Congress regulate 40 million American citizens who are outside their regulatory scheme and ask them to participate? Now, the respondent's argument is that they can because they're engaged in the activity. Now,
They require people to eat.
no, Your Honor.
Why not?
Well,
Under
simply,
your logic.
yes, Your Honor. It really stems from the unique nature of the health insurance industry that is a risk market.
As opposed to the eating industry, where people also need to eat to survive.
Yes, Your Honor, but of course it does not hinge on the necessity of the action, but simply that the action is taking place. Now, Congress can justify a regulation of the health insurance industry, as my first point would be that it meets all three prongs of the Lopez test. It deals with instrumentalities, channels, and substantial effects. Now, this Court has created a comprehensive regulation through the Affordable Health Care Act. just like the Agricultural Adjustment Act at issue in Wickard and the Controlled Substances Act at issue in Gonzalez, this court has created a national regulatory scheme of an important market.
One could strike down one portion of this act requiring the mandate, and the rest could still be upheld, couldn't it?
No, Your Honor, for two reasons. First, there is no severability clause. The individual mandate must come with the rest of the Affordable Health Care Act.
Only because that's the underlying policy, but in theory they could have adopted the regulations without the individual mandate, and that would not have been a problem.
No, Your Honor, in fact they could not. And this takes us to the heart of Respondent's argument. The heart of the Respondent's argument is that there is a comprehensive regulatory scheme. And if we look to the congressional findings, Congress makes it clear the individual mandate is essential. Congress has created a regulatory scheme of the health insurance industry. And they state in their findings, paragraphs C, E, G, and H of your record on page 19, the individual mandate is reasonably adapted to the legitimate end of regulating the health insurance industry. Now, if we look to this court's rulings in United States versus Comstock and applying the necessary and proper clause of the Constitution, we see that the relevant inquiry in applying that clause is simply whether the means chosen are reasonably adapted to the attainment of a legitimate end under commerce power.
Now, one could have done that through a tax as opposed to requiring somebody to purchase a commodity from a private entity. How can we force people to enter into private contracts under a system like this without being able to force them to purchase a certain amount of food, without being able to force them to purchase a certain amount of shelter, without being able to force them to purchase other things that are necessary for existence? I mean, this is what I'm not getting. And where's the limiting principle that distinguishes this from those other necessary activities?
Yes, Your Honor. There are actually three limiting principles that Respondent would put forward. The first is, as I stated before, the unique nature of the health insurance industry.
What's unique about it that's not shared by consumption of food and shelter and other similar commodities?
Your Honor, the unique nature is that the low threshold of participation. Everyone participates in the health insurance market and the risk market simply by getting up, walking across a busy street, driving on the interstate, or holding a hot cup of coffee. And they have an involuntary and inevitable entrance into a health insurance and healthcare market that they do not most likely have the means to pay for. However, the other limiting factor is simply the fact that the entrance into a market such as food is purchasing food, or growing wheat, or cultivating marijuana.
So as long as a lot of people do something but not enough, we can regulate, is what you're saying?
No, Your Honor. The fact is, as soon as someone is engaged in activity, they can be regulated if Congress can prove that it's part of a larger regulatory scheme that is protected by the commerce power. Now, the other limiting factor in this case takes us to Wickard and Gonzalez. Now, in that case, Congress concluded that leaving several thousand wheat farmers growing wheat for home consumption outside their larger regulatory scheme would substantially affect market prices and conditions, and therefore could be regulated. Now, we look to Gonzalez. This Congress decided and this court upheld that leaving several thousand people in California growing homegrown marijuana for personal consumption outside their larger regulatory scheme would substantially...
But then again, those are individuals who are making an affirmative decision to do something. You can't have it both ways. You can't say that you're both doing something and not doing enough so as to justify bringing you into a regulatory scheme. I mean, one or the other. You can't have both.
No, Your Honor, we're not asking for both. We're simply saying that the health insurance market, everyone does participate in activity by the nature of the market.
Well, let's say there's an individual who chooses not to purchase insurance. Let's say that person becomes sick. Let's say that a hospital refuses to admit that person because they don't have insurance, and there is no federal statutes that mandates that the hospital take that person in. That person has made a decision not to purchase health insurance. That person has suffered the consequences. But one could imagine that that's one way we could structure our system of government, or our healthcare system. And in that case, would there be activity that is regulatable under the Commerce Clause?
Your Honor, I'm not sure if I understood your complete question, but
I'm curious if anybody did. But
my best answer to that is that if Congress decided to regulate the health insurance industry and created that broad regulatory scheme, this court could uphold it as constitutional. The question is whether the broad regulatory scheme they have enacted is, in fact, a regulation of interstate commerce, and health insurance clearly
So
is.
Congress passed a law that said, okay, you choose not to have insurance, you go to the emergency room, sorry, you're dead on the road. Can Congress pass that law?
Congress could certainly pass that law, but it would certainly not be in the interest of the general welfare of our people. However, we
Well,
have...
if Congress can pass that law, isn't this law the same as that? It's just a different kind of punishment.
Yes,
Just
Your Honor.
money, not dead.
Yes, Your Honor. In fact, we would argue that this law is much better than that alternative. This law, in fact, requires Congress, is allowing Congress to conclude that leaving 40 million uninsured individuals outside of the regulatory scheme will substantially affect market prices and
First
conditions.
off, but that's all premised on the fact that we include them in the regulatory scheme when we provide them health care when they enter the emergency room. If we exclude them from the scheme, then it wouldn't be necessary for it to be a comprehensive scheme.
Yes,
You could
Your
have people choose to participate in the scheme, the way that people who choose to work participate in Social Security, where those who don't earn enough Social Security taxable income do not get the benefits of Social Security. The point is that one could have a consistent regime where these folks are not included, and therefore their participation is not necessary, and therefore it exceeds Congress's power to forcibly include them in the system.
Yes, Your Honor. I see my time is up. Could I briefly answer your question?
Yes.
Your Honors, the fact is that the regulatory scheme we have to look at is the Affordable Health Care Act. Congress has shown in their finding it's a comprehensive regulation, and that the individual mandate is essential, in paragraphs G and H, essential to create an effective health insurance market. For this reason, under necessary and proper, and under the substantial effects test, we urge this Court to find in favor of Respondent.
Please reintroduce yourself.
Madam Chief Justice, Your Honors, and may it please the Court, my name is Alex Harris, and I rise to represent the Respondent, the State of Olympus, in arguments on the 14th Amendment. Now, there are three questions before this Court today in determining and applying the correct legal test, rational basis on the one hand, or strict scrutiny on the other. In determining the proper test, first, what is a fundamental right? Second, is same-sex marriage a fundamental right? And having determined that rational basis is the proper legal test, does Proposition 225 meet rational basis scrutiny? Now, there are also two distinct bodies of case law before this Court in our record. The first body of case law traces this Court's jurisprudence on the topic of marriage, the seminal case being Loving v. Virginia in 1967, and including Zablocki v. Redhale and Griswold v. Connecticut. But the second body of case law traces jurisprudence on the rights and the liberties of homosexuals. And the seminal case in this case is Lawrence v. Texas in 2003, and also including Rumber v. Evans and Goodridge v. Department of Public Health. Respondent would respectfully ask this Court to rely on that second body of cases for the simple reason that the case at bar deals with same-sex marriage, not traditional marriage, which this Court has separately designated as a fundamental right. Of course, this begs the question, what is a fundamental right? This Court has repeatedly upheld, most recently in Washington v. Glucksberg, cited in our record in Wilson v. Ake, and in Justice Scalia's dissent in Lawrence v. Texas, that a fundamental right are those rights and privileges which are, quote, objectively deeply rooted in our nation's history and traditions. In Reno v. Flores, also cited in Justice Scalia's dissent in Lawrence, fundamental rights are those privileges long recognized at common law as essential to the orderly pursuit of happiness.
But Mr. Harris, isn't deeply rooted change as time changes? I mean, can't we look at this and assume that there's some animus against homosexuality in the statute?
No, Your Honor. First, there is no animus in the statute towards homosexual. The people of Olympus and the state of Olympus simply desire to protect both the traditional concept of marriage, which they believe to result in the most stable family structure, but also to protect significant financial burdens which would accrue upon the state with the recognition of same-sex marriage. It is not any animus.
With regard to your argument as to the significant financial burdens, aren't you really overstating that which is really no burden at all? I mean, in other words, people are going to be licensed to how how big a burden is it to issue more marriage licenses, and well, now we have to afford them other benefits. Well, each of those two individuals are going to be afforded benefits anyway. So aren't you way overstating this notion that it's going to burden the state? Aren't you really simply wanting us to do a popularity poll, and based on a popularity poll say, well, most people really don't like this, and so we're going to do what most people want?
No, Chief Justice Wicker. What we are asking is that this court apply the proper legal test to the statute in question. And that proper test is rational basis. For the simple reason, again, that same-sex marriage is not a fundamental right deserving of fundamental rights protection.
Well, again, it's a definitional question. If it's a question of, do you have the right to marry the person of your choice, then one could argue that gay men and lesbians should have that right as much as anybody else. If you define it in terms of you have the right to marry the person of the opposite sex of your choice, then you could argue that it's, the fundamental right is limited to heterosexual couples. But isn't part of the task here to decide which is the appropriate definition when the court has spoken of marriage as a fundamental right?
Yes, Your Honor, that is an
Shouldn't
important...
that be afforded strict scrutiny?
No, Your Honor, because as this court held in Tigner versus Texas, cited in our record in Flyva versus Doe, our Constitution does not require things that are different in fact or opinion to be treated by law as though they were the same. Same-sex marriage is different from traditional marriage, not only in fact and opinion, but in the traditions and the history of this nation, and in this court's...
As was the idea of marriage between an African-American man and a Caucasian woman at one point.
Yes, Your Honor.
There is a long, deeply rooted history that covers that particular issue, is there not?
Yes, Your Honor. There are two responses to that. First, it is a fundamentally false analogy to equate anti-miscegenation laws, such as in Loving versus Virginia, with Proposition 225, simply because in Loving versus Virginia, we were dealing with whether to expand the pool of those allowed to enter the historically understood institution of marriage between a man and a woman, whereas in the case at bar, we are dealing with a redefinition and a reforming of what marriage has always been. So that is a difference. The second argument, which actually goes back to a comment that Chief Justice Wicker made to opposing counsel, is that in Loving versus Virginia, we saw a lead-up to that decision, the Civil Rights Acts of the 1960s, the passage of the 14th Amendment, which forbade invidious race-based distinctions, and a dwindling number of states that still had anti-miscegenation laws on the books. In the case at bar, we see the exact opposite, where an increasing number of states have voted...
Doesn't Loving stand for the proposition that there are certain things that are so fundamental that it doesn't matter whether or not it's the most popular thing to do? In Loving, didn't we one more time say, oh my God, we made a horrible decision when we wrote Dred Scott? Isn't this like that? Isn't this not a popularity contest? Isn't this a question of what Americans have rights to do, one being the right to be just left alone?
Yes and no, Chief Justice Wicker. Because if we look at this court's decision in Loving versus Virginia, this court did find that there was a fundamental right to marriage. However, they also noted the lead-up, as I said, and as you mentioned to opposing counsel, the lead-up in the laws and the understanding of our society in general to overturn very deep-rooted ideas and traditions.
Can one look at global trends in answering this question? I mean, you point obviously to the experience of the several states in considering these sorts of propositions, but one could equally well draw upon the experience in a number of other countries where not only have such unions been recognized, but after the fact it's been mostly a non-issue. Right? I mean, isn't that kind of transformative experience in the rest of the world supposed to inform decisions like this?
No, Your Honor, because we are asked to look at Proposition 225 and evaluate it under the United States Constitution and not the laws of other nations.
But you're drawing upon this deeply rooted, fundamental right in society, and one I assume that transcends the existence of this federal republic, right? And to the extent that those very countries from whom we imported the idea of marriage have now extended it, doesn't that suggest that we should follow their example?
Respectfully, no, Your Honor, because the basis of Proposition 225 is not only in the deeply rooted traditions and history of our country, which this court has repeatedly affirmed is the definition of a fundamental right deserving of strict scrutiny, But we also see that in this court's own jurisprudence, it has never extended a fundamental right to same-sex marriage nor a suspect class to homosexuals. If we look to the case law dealing with the rights and liberties of homosexuals, this becomes clear. First, in Goodridge versus Department of Public Health, the Supreme Judicial Court of Massachusetts did not find a fundamental right to same-sex marriage under the United States Constitution, emphasizing instead their own state constitution's unique liberty protections. They stated, the brilliance of our federal system is that each state's constitution has vitality specific to its own traditions, and every state is free to decide difficult issues of personal liberty as their own.
But then, interesting, does marriage affect interstate commerce? Well, we are a very mobile society, and if we leave this to the states, we end up with exactly what happened in this case. Two men got married in a place where it was legal, and then they moved to a place where it was not legal, and all kinds of consequences ensued. So isn't this something that should not be left to the states, but must be grappled with by us?
No, Your Honor. Historically, this court has always left decisions on the regulation of marriage to the states. Moreover, again, to bring it back to the question at bar, the question is what test we apply to the statute in question. And because this court has always applied rational basis and not strict scrutiny to issues of homosexual rights and liberties, this is the proper test in the case at bar. Now, under Heller v. Doe, this court held that under rational basis review, a classification must be upheld if there is any reasonably conceivable state of facts that would justify the classification. Now, the state of Olympus, is not required under Heller to produce evidence for the rationality of its classification.
Well, let me ask you the following. Could we adopt a statute that says that gay men and lesbians cannot buy insurance, since that was the topic of the first discussion?
With due respect,
if we analogize essentially marriage to a private contract that has certain benefits conferred on it by the state, why not use the analogy of the insurance contract? Could you have a statute that denied gay men and lesbians the right to purchase insurance?
with all due respect, Your Honor, first I see my time is up. May I briefly answer the question?
Yes.
With all due respect, Your Honor, to speak to the Commerce Clause issue would be in violation of the rules of
No, I'm just using it by analogy to say that if you view marriage as a private contract, then it would not survive rational basis scrutiny, presumably to say that a particular class of individuals could not enter into such a contract. I'm just using the insurance contract as an example. You can substitute any other kind of contract you want. If marriage is viewed solely as a contract, and I know you're going to argue against that, but if marriage were viewed solely as a contract, wouldn't it fail rational basis scrutiny to have a statute that says that gay men and lesbians cannot enter into that contract?
Once again, Your Honor, may I
Yes.
answer the question? Perhaps, Your Honor, again, what we are evaluating is the statute in question and the understanding and the treatment of marriage as this court and as the state of Olympus and our nation have traditionally done so. And as such, because the discrimination does not violate a fundamental right, they are allowed to discriminate and classify for rational reasons, and the state of Olympus has clearly done so.
Thank you. You have 3 minutes.
Madam Chief Justice, excuse me, Madam Chief Justice, and may it please the court. By way of rebuttal, we have 2 points. First, Congress's history and regulation of the healthcare market does not save the individual mandate through the necessary and proper clause. And second, the state does not have an interest, and if it cannot produce one, it will fail even rational basis review. Your Honors, opposing counsel has claimed that the individual mandate is justified under the necessary and proper clause of the Constitution. However, in Gonzalez v. Reich, the court held that such regulations were acceptable only when they are necessary to protect the economic market. And as Your Honors...
Necessary to protect the economic market. Aren't we faced with this particular market being one which is in incredible crisis?
Yes, Your Honor, it is in crisis. But as Your Honors noted earlier, there are several alternatives Congress could choose that would accomplish the same goal. Congress could go so far as to say that those people arriving in emergency rooms could not receive care if they could not pay for it. Such a policy would be harsh, but it would be constitutional. because there is some activity.
What if you couldn't tell if somebody was insured because they were unconscious?
Your Honor, there are a variety of options that Congress could choose. The fact of the matter is compelling individuals to enter a market is not one of them. In Gonzalez versus Reich, the court defined a strict criteria for when individuals engage in an economic
But
activity.
there are implied in law contracts that deal with the provision of medical care. I mean, isn't somebody who is unable to consent to medical care deemed to consent at law to the provision of medical services, and can't that person be liable for expenses resulting from their contract?
Your Honor, I'm afraid I can't speak to the specifics of this contract since they're not included within the record.
Let me ask you a basic question. In the Wickard case, where we're talking about the Agriculture Department's body of law, they were paying farmers not to act.
Yes, sir.
It was inactivity, not activity. And so haven't we already regulated inactivity?
Respectfully, Your Honor, I would not read that from Wickard versus Filbert. The court in that case regulated the production, distribution, and consumption of farmers who had already entered the market. They did not force individuals to enter a market or force or regulate any inactivity. And Your Honor's opposing counsel has claimed that they do not need to produce an interest to satisfy rational basis review under Heller versus Doe. And that is incorrect. They must produce some interest, and that interest must not be the discrimination against homosexual individuals. They must produce some policy reason for why homosexuals should not be given the same benefits under the law. Thank you.
Thank you all. Ladies and gentlemen, we have heard all of the arguments. We will take this matter under advisement and render our opinion in due course.